Welcome to another UBC Real Estate Exam prep video. In today's video, we'll be diving into Chapter 15, Introduction to Mortgage Law. If you're preparing for the UBC Real Estate Exam, this chapter is crucial to understanding the legal aspects of mortgages in Canada. We've put together 41 practice questions to help you get a solid grasp of mortgage rights, foreclosure laws, and key legal principles. Whether you're new to real estate law or need a refresher, these questions will guide you through the important topics you'll need to know to pass your exam with confidence. Stick around as we break down each question with clear explanations, helping you master mortgage law and feel ready for your UBC real estate exam. Let's get started. Question 1. A mortgage of the mortgagor's equity of redemption is called Option B. An equitable mortgage is the correct answer. Explanation. A borrower who grants a legal mortgage retains an equitable interest in the property, which is referred to as the equity of redemption. This equitable interest can be used as collateral for another loan by creating a second or subsequent mortgage. These are considered mortgages of the equity of redemption and are categorized as equitable mortgages. Option A, incorrect. A lien is a type of security interest but is not a mortgage. Option C, incorrect. An agreement for sale is not a mortgage but a contractual arrangement for the transfer of property under specified terms. Option D, incorrect. A lease is a legal agreement granting possession of property for a set time, not a mortgage. Question 2. An arrangement where a lender makes payments to a borrower over the term of the mortgage that are paid back at the end of the term is referred to as D. A reverse annuity mortgage is the correction option here. A reverse annuity mortgage is a loan where the lender provides periodic payments to the borrower over the loan term. The borrower repays the loan, including accrued interest, at the end of the term, often by selling the property or refinancing. This arrangement is commonly used by senior homeowners to access equity in their homes while still residing in them. Option A, incorrect. An interim blanket mortgage secures multiple properties under one loan during development or construction projects, but does not involve periodic payments from the lender to the borrower. Option B, incorrect. A vendor take-back mortgage occurs when the seller of a property finances the purchase by lending the buyer part of the purchase price, not periodic payments. Option C, incorrect. Bridge financing provides short-term loans to cover immediate financial needs, such as purchasing a new home before selling the old one, but does not involve payments from the lender to the borrower. Result: the correct answer is D, a reverse annuity mortgage. Question 3. Which of the following statements concerning mortgages is false? The false statement is A, a mortgage is a loan. Explanation: this statement is false because a mortgage is not a loan. It is a legal instrument that serves as security for a loan. The loan itself is a separate financial agreement. Option B, true. A mortgage is an interest in land that is created by a contract between the borrower, mortgagor, and the lender, mortgagee. Option C, true. The relationship between the borrower and the lender in a mortgage is that of debtor and creditor. The borrower owes the lender a debt secured by the mortgage. Option D, true. In British Columbia, mortgages are recorded on the property's title as a charge, ensuring the lender's security interest is legally documented. Question 4. In which of the following situations would bridge financing be the most advantageous form of financing for Jonathan? A. Jonathan and his wife recently had a second child and are looking to purchase a larger home. Jonathan and his wife have found. Explanation: bridge financing is a short-term loan used to bridge the gap between the purchase of a new property and the sale of an existing one. In this case, Jonathan and his wife need funds for a down payment on a new home while their current home remains unsold, making bridge financing the ideal solution. Option B, incorrect. A first-time homebuyer would typically use a conventional mortgage for financing. Bridge financing is not relevant since there is no existing property to sell. Option C, incorrect. A reverse annuity mortgage would be the best option for accessing home equity for retirees seeking to make a large purchase, like a recreational vehicle. Option D, incorrect. Jonathan plans to finance the new purchase entirely from savings, so no financing, including bridge financing, is required. Question 5. After a borrower has given a mortgage of real property, the borrower's remaining interest is described at law as correction option C, the equity of redemption. Explanation. The equity of redemption is the borrower's remaining interest in the mortgaged property, which allows them to reclaim full ownership upon repayment of the loan. It ensures that the borrower retains a legal right to redeem the property even after granting the mortgage. Option A. Incorrect. A right of foreclosure is a remedy available to lenders, not an interest retained by borrowers, and arises only in cases of borrower default. Option B. Incorrect. At common law, a mortgage transferred both title and possession of the property to the lender, leaving no remaining interest for the borrower. Option D. Incorrect. An equitable mortgage arises when the mortgage cannot be registered as a legal mortgage, but does not describe the interest retained by the borrower. Question 6. The transfer by the borrower of the equity of redemption to a subsequent buyer does not always relieve the borrower of the covenant to repay the debt. However, there are circumstances where the borrower may be relieved of liability on the personal covenant. Which one of the following events would not relieve the borrower from this liability? Option B. The borrower has sold the property with the knowledge of the lender is the correct answer. Explanation. Simply selling the property with the lender's knowledge does not relieve the borrower from liability on the personal covenant, unless the lender explicitly releases the borrower or a new contract is established. The original borrower remains liable. Option A. Incorrect. A release from the lender explicitly absolves the borrower of personal liability. Option C. Incorrect. Under specific provisions of the Property Law Act, the borrower may be legally released from liability. Option D. Incorrect. If the original contract between the lender and borrower is replaced by a new contract between the lender and the subsequent purchaser, the borrower is no longer liable. Question 7. A contract between the seller of real estate and the buyer, whereby the vendor agrees to sell their interest in that land to the buyer for a specified price, payable in installments, and upon payment of the price in full to transfer title to the buyer is called A.N. Option C is the correct answer. Agreement for sale. Explanation. In an agreement for sale, the vendor acts as the lender by allowing the buyer to pay in installments. The vendor retains ownership of the property until the purchase price is paid in full, at which point the title is transferred to the buyer. Option A. Incorrect. An equitable mortgage involves using a property as collateral without transferring legal title, but does not relate to installment payments or delayed transfer of ownership. Option B. Incorrect. A bonus mortgage refers to a mortgage where the lender receives additional compensation, not a purchase agreement. Option D. Incorrect. A disguised form of mortgage is a transaction that may resemble a mortgage but is not the same as an agreement for sale. Question 8. An option to purchase the mortgaged property given by the mortgagor to the mortgagee at the time the mortgage is negotiated is, the correct option is B. Void. Explanation. A fundamental principle of mortgage law prohibits clogging the equity of redemption, which is the mortgagor's, borrower's, right to repay the mortgage and reclaim the property free of any encumbrances. Granting an option to purchase at the time of mortgage negotiation is considered a clog on this right, as it could prevent the mortgagor from redeeming the property. Therefore, such an option is void. Option A. Incorrect. Even if the mortgagor receives independent legal advice, the prohibition against clogging the equity of redemption still applies, rendering the option void. Option C. Incorrect. A void option cannot be enforceable under any circumstances. Option D. Incorrect. The equity of redemption refers to the borrower's right to repay the mortgage and reclaim their property, not an option to purchase the property. Question 9. Which of the following is not a common covenant of the borrower? The correct answer is D. Provision to waive the rescission rights under the Mortgage Brokers Act. Explanation. Borrowers commonly covenant to pay all property taxes, levies, and assessments to ensure that the property remains free of tax liens, which could jeopardize the lender's security. Option B. Incorrect. Borrowers are required to maintain the property in good condition to prevent any decrease in value, which could impact the lender's security interest. Option C. Incorrect. Borrowers are often required to insure the buildings on the property to protect the lender's collateral in case of loss or damage. The correct answer is D, provision to waive the rescission rights under the Mortgage Brokers Act. It is not a common covenant for borrowers to waive rescission rights under the Mortgage Brokers Act or any other legal protections. Such a waiver is not standard practice and could be unenforceable. Question 10. In a mortgage transaction, the mortgagee is, the correct answer is D, granted the mortgage as security for a loan. Explanation. Option A, incorrect. The borrower is referred to as the mortgagor, not the mortgagee. Option B, incorrect. The fee simple owner is typically the mortgagor, who retains ownership of the property while granting the mortgage as security. Option C, incorrect. The equitable right to redeem the mortgaged property refers to the mortgagor's ability to repay the loan and reclaim unencumbered title, not the role of the mortgagee. Option D, correct. The mortgagee is the lender in a mortgage transaction. They are granted the mortgage as security for the loan they provide to the mortgagor. Question 11. The Criminal Code defines a criminal rate of interest as an annual percentage rate in excess of 20%. The correct answer is D. The Interest Act provides that if a mortgage agreement does not specify the rate of interest chargeable and does not require blended payments, the rate allowed by law is 5%. The Interest Act ensures that when a mortgage agreement does not specify the interest rate to be charged and does not require blended payments, combined principal and interest, the default rate permitted by law is 5% per annum. This protects borrowers from unspecified or arbitrary rates being applied in such situations. Other options. Option A, incorrect. The Interest Act does not require the interest rate chargeable under a mortgage to be reasonable. Instead, it permits any agreed-upon rate unless otherwise restricted by federal law. Option B, incorrect. The Criminal Code defines a criminal rate of interest as exceeding 35%, not 20%. Option C, incorrect. Section 10 of the Interest Act allows prepayment rights after 5 years for individual borrowers, provided the mortgage specifies that it is not payable for more than 5 years from the date of the mortgage. It does not explicitly exclude business purposes or corporate borrowers. Question 12. When a mortgagor grants a mortgage after having a registered first mortgage on title, the mortgagor has created, correct answer, A, an equitable mortgage. Explanation. The first registered mortgage on title is considered a legal mortgage, which conveys the primary legal interest in the property to the lender. Any additional mortgage registered subsequently charges the borrower's equity of redemption and is classified as an equitable mortgage. Option B is incorrect because a legal mortgage refers to the first registered mortgage, not the subsequent one. Option C is incorrect because an assignment of a first mortgage occurs when a lender transfers their rights to another party, not when a second mortgage is created. Option D is incorrect because a vendor take-back mortgage involves the vendor of a property providing financing to the purchaser, not a subsequent charge created by the mortgagor. Question 13. The principle of good faith includes, correct answer, D, the duty of parties to a contract to act honestly in the performance of their contractual obligations. Explanation. The principle of good faith requires parties to a contract to act honestly and in good faith during the performance of their contractual obligations. This includes refraining from actions that could undermine the purpose of the agreement. Option 1 is incorrect, because while fulfilling obligations to the best of one's ability is a general expectation, the principle of good faith specifically focuses on honesty and not just performance. Option 2 is incorrect, because while a mortgagee has duties in certain circumstances, such as in foreclosure proceedings, the principle of good faith is not limited to procedural aspects like giving the mortgagor time to cure a default. Option 3 is incorrect, because the duty not to make false representations applies to contract negotiations. But good faith encompasses more than just preventing falsehoods. It involves acting honestly throughout the contract's performance. Question 14. A term of the mortgage provides that the full outstanding balance will become due and payable in the event of default by the borrower in making any payment. This term is known as, correct answer, D, the acceleration clause. Explanation. The acceleration clause is a provision in a mortgage agreement that allows the lender to demand the full outstanding balance of the loan if the borrower defaults on any payment, effectively advancing the maturity date of the loan. Option 1 is incorrect because the repayment clause refers to the part of the mortgage agreement that sets the final due date for repayment of the loan in full, not the conditions under which the loan balance can be accelerated. Option 2 is incorrect because the personal covenant is the borrower's promise to repay the loan, including the principal and interest. It does not deal with the acceleration of the loan in case of default. Option 3 is incorrect because the omnibus clause provides the lender with alternative remedies for default, but it is not specifically about accelerating the loan. Question 15. ABC Loan Co., ABC, has agreed to lend $2 million to Devco Ltd. in exchange for a registered first mortgage against Devco's current residential construction project. The loan is to be paid out in 4 equal installments over a 5-month period, but all payments are at the discretion of ABC under the advances clause in the mortgage. The first installment has been paid, and it is now time to pay out the second installment. ABC has discovered that a builder's lien has been filed against Devco's property. You correctly advise ABC that. Correct answer, B. If the second installment is advanced to Devco, the lien claimant will have priority over this and any other advances made under the mortgage after the date of registration of the lien. Explanation. Under the Builder's Lien Act, BLA, a builder's lien filed against the property takes priority over any mortgage advances made after the lien is registered, even if the mortgage was registered first. Therefore, the lien claimant has priority over ABC's subsequent advances after the lien is filed. Option A is incorrect because the advances clause in the mortgage gives ABC discretion over whether or not to advance further payments. Refusing to pay out the second installment would not be a breach of the mortgage contract. Option C is incorrect because the lien, once registered, takes priority over any future mortgage advances, even if the mortgage was registered first. Option D is incorrect because option B is correct. Question 16. Under the Environmental Management Act, a mortgage lender may be liable for the remediation of a contaminated site if the lender, correct answer, C, becomes the registered owner of the site. Explanation. Under the Environmental Management Act, a mortgage lender may become liable for the remediation of a contaminated site if they become the registered owner of the property. This typically happens when the lender forecloses on the property and takes ownership. Once they own the property, they may be held responsible for any environmental cleanup required. Option A is incorrect because lenders are not liable if they are merely involved in financial matters and do not take control or responsibility for the property in a way that could contribute to contamination. Option B is incorrect because while a lender may include environmental conditions in a security agreement, this does not automatically make them liable for the cleanup of contamination unless their actions lead to or exacerbate contamination. Option D is incorrect because appointing a person to inspect a contaminated site does not create liability for the lender. Lenders can perform due diligence and inspections without becoming liable under the Environmental Management Act, as long as they do not take actions that worsen the contamination. Question 17. Which of the following statements regarding mortgagees is false? D. Once the mortgage terms have been agreed to by the mortgagor and the mortgagee is bound to advance the total amount of the funds when requested by the borrower, regardless of the terms of the mortgage. This is a false statement. Explanation. Option D is false because most mortgages contain terms that allow the mortgagee lender discretion in advancing funds. The lender is not obligated to provide the full amount of the loan upon request from the borrower unless all terms and conditions, such as the removal of liens or other requirements, have been met. For example, if a builder's lien is filed, the lender may refuse to advance further funds until the lien is removed. Therefore, the lender is not bound to advance funds under all circumstances. Option A is true, because a mortgagee can require a guarantor to provide additional security for the loan, with the guarantor making a personal covenant to pay. Option B is true, because under the Strata Property Act, a mortgagee can request the right to vote at strata meetings on matters relating to the security of the mortgage, such as insurance and maintenance issues. Option C is true, because mortgagees generally have discretion in choosing from available remedies when a borrower defaults. This discretion allows lenders to select the most appropriate course of action to recover their loan amount. Question 18I is a document evidencing a debt owed by the mortgagor to the mortgagee, which carries with it the equitable right to redeem the property on payment of the debt, even after default. Correct answer, C, I, a mortgage, 2 mortgagors. Explanation. Option C is correct, because a mortgage is a legal document that evidences the debt owed by the mortgagor, borrower, to the mortgagee lender. This mortgage carries with it the mortgagor's equitable right to redeem the property by paying the debt, even after default. This right allows the borrower to reclaim the property by paying off the mortgage debt. Option A is incorrect because the mortgagee, the lender, does not have the equitable right to redeem the property. The right belongs to the mortgagor, the borrower. Option B is incorrect because an agreement for sale does not typically involve a right to redeem property, and it relates to a sale of the property rather than a mortgage. Option D is incorrect because the deposit of a duplicate certificate of title is related to a different form of security, not a mortgage, and it does not relate to the right of redemption. Question 19. A contract between a seller and a buyer whereby the seller agrees to sell its interest in certain property to the buyer for a price payable by installments, and then to convey legal title to the buyer after payment of the purchase price in the manner agreed, is called, correct answer D, an agreement for sale. Explanation. Option D is correct, because an agreement for sale is a contract where the buyer agrees to pay the purchase price in installments directly to the seller, and legal title is conveyed only after full payment is made. The seller retains legal title until the purchase price is fully paid. Option A is incorrect because a mortgage involves securing a loan against property, and the title to the property is transferred to the lender as collateral until the loan is repaid. Option B is incorrect because an agreement of purchase and sale is a more general contract for the sale of property. It involves transferring the legal title to the buyer, but doesn't typically structure the purchase as payments over time. Option C is incorrect because the equity of redemption refers to the mortgagor's right to redeem their property after defaulting on a mortgage, not a contract for the sale of property. Question 20. Which of the following statements regarding the effect of registration of a mortgage in a British Columbia land title office is true? Correct answer C. Registration of a mortgage raises only a rebuttable presumption that the mortgage is valid. A registered mortgage is not guaranteed under the British Columbia land registration system. Explanation. British Columbia's land registration system, the registration of a mortgage creates a rebuttable presumption of its validity, but it does not guarantee the mortgage's validity. It is subject to challenge, and other factors, such as fraud or mistakes, can affect its enforceability. Option A is incorrect, because while the registration of a mortgage gives notice of the mortgage's existence, it does not automatically provide conclusive evidence of entitlement to the land unless other conditions are met, like ownership and the terms of the mortgage. Option B is incorrect, because even if a mortgage is not registered, it may still be enforceable between the parties, the mortgagor and the mortgagee, though it may not be enforceable against third parties. Option D is incorrect, because option C is correct. Question 21. The court order usually obtained first in a foreclosure action is incorrect answer. A. Order nisi. Explanation. The order nisi is the first court order typically granted in a foreclosure action. It is a preliminary step that establishes the final redemption period during which the mortgagor borrower can redeem the property by repaying the debt owed to the mortgagee lender. Option B is incorrect, because the order absolute is granted if the mortgagor fails to redeem the mortgage during the redemption period, effectively transferring ownership to the mortgagee. Option C is incorrect, because an order for sale is a separate remedy that may be pursued if the property is to be sold rather than foreclosed. Option D is incorrect, because an order for specific performance applies to contract enforcement, not foreclosure actions. Question 22. A court has power to reopen a mortgage transaction where, having regard to the risk and to all the circumstances, it is of the opinion that the cost of borrowing is excessive or harsh and unconscionable. In which one of the following statutes is this power contained? Correct answer: D. The Business Practices and Consumer Protection Act. Explanation: the Business Practices and Consumer Protection Act grants courts the authority to intervene in mortgage or lending transactions when the cost of borrowing is deemed excessive or the transaction is harsh and unconscionable. This provision ensures consumer protection in cases of exploitative lending practices. Option A is incorrect because the Interest Act deals with interest rate disclosure and specific provisions like prepayment rights, but does not empower courts to reopen transactions based on fairness. Option B is incorrect because the Mortgage Brokers Act governs the conduct of mortgage brokers but does not address harsh or unconscionable transactions. Option C is incorrect because the Real Estate Services Act pertains to real estate transactions and licensing requirements, not to mortgage transaction fairness. Question 23. Which one of the following is not a provision of the Interest Act? Correct answer: A. No interest rate higher than 25% shall be provided for in a mortgage document. Explanation: the Interest Act does not impose a cap on interest rates in mortgage documents. Interest rates are subject to agreements between parties, but can be challenged under the criminal code if they exceed the criminal rate, currently over 35%. Option B is incorrect because Section 6 of the Interest Act requires a statement of the interest rate yearly or half-yearly, not in advance, when a mortgage involves blended payments. Option C is incorrect because Section 3 of the Interest Act states that when no interest rate is specified in a mortgage document, the rate defaulted by law is 5% per annum. Option D is incorrect because Section 8 of the Interest Act limits the interest rate on arrears to not exceed the regular interest rate on the principal. Question 24. A lender who is foreclosing may ask the court to appoint a receiver where the property being foreclosed is. Correct answer: D. Any one of the above. Explanation: a lender can request the court to appoint a receiver in any of the situations described. Option A. A large residential apartment building often involves managing multiple rental units, and a receiver may be necessary to collect rents and manage operations during foreclosure. Option B. A single-family dwelling with a tenant may require a receiver to manage tenancy issues and collect rental income. Option C. An abandoned property may need a receiver to secure the premises, pay expenses, and maintain the property value. In all these scenarios, the receiver acts as an impartial party to manage the property until foreclosure proceedings are resolved. Question 25. Any clause contained in a mortgage that clogs the equity of redemption is. Correct answer: B. Void. Explanation: a clog on the equity of redemption refers to any term in a mortgage agreement that seeks to prevent or restrict the borrower from fully redeeming the property upon repayment of the loan. Mortgage law implies a term that guarantees the borrower the right to regain clear title to the property upon repayment. Option B is correct because such a clause is considered void and unenforceable. Courts ensure borrowers retain their right to equity of redemption, which cannot be contractually waived or diminished. Option A is incorrect because clauses that clog the equity of redemption are not valid and cannot be enforced. Option C is incorrect because while such clauses are void, they are not illegal. They are simply unenforceable by the courts. Option D is incorrect because issues related to unreasonable restraints of trade are separate from the principle of equity of redemption and are not relevant to this specific question. Question 26. Under the British Columbia land title system, a mortgage is registered as a charge against the property of which the mortgagor is. Correct answer: C. The registered owner. Explanation: under British Columbia's Torrens land title system, a mortgage is registered as a charge against the property. However, the borrower, mortgagor, remains the registered owner of the property, while the lender, mortgagee, holds the mortgage as a charge on the title. Option C is correct because the title continues to reflect the borrower, mortgagor, as the registered owner even after the mortgage is registered. Option A and B are incorrect because the mortgagor is not considered a charge holder. Charge holders refer to entities like the lender, not the property owner. Option D is incorrect because mortgages are registered as charges against the title, ensuring the lender's interest is secured and enforceable under the land title system. Question 27. Under the Land Title Act, in British Columbia, a mortgage is registered on the title as. Correct answer A, a charge. Explanation. In British Columbia, under the Torrens system of land registration, mortgages are registered as charges against the title of the property. This allows the lender to secure its interest in the property as collateral for the loan. Option A is correct because mortgages are explicitly recorded as charges. Option B is incorrect because an agreement for sale refers to a purchase agreement, not a mortgage. Option C is incorrect because a right to purchase is a separate legal concept unrelated to the registration of a mortgage. Option D is incorrect because a restrictive covenant imposes specific restrictions on the use of land, not a mortgage agreement. Question 28. In British Columbia, a lender who holds a mortgage registered as a charge on an otherwise clear title to a borrower's land has. Correct answer, B, an interest in land created by contract. Explanation. A mortgage represents an interest in land that is created by contract to secure the lender's loan. It gives the lender legal rights over the property in case of default, but it is not the loan itself. Option B is correct because the mortgage creates a contractual interest in land for the lender. Option A is incorrect because the right of redemption is held by the mortgagor borrower, not the lender. Option C is incorrect because certain types of claims, such as builder's liens, property tax liens, and others, can take priority over the mortgage, even if it was registered first. Option D is incorrect because retaining a duplicate certificate of title to secure a loan constitutes an equitable mortgage rather than a registered legal mortgage. Question 29. Which of the following clauses contained in a mortgage would constitute a clog on the equity of redemption and therefore be void? Correct answer. B. Option to purchase clause. Explanation. An option to purchase clause would be considered a clog on the equity of redemption because it could prevent the borrower, mortgagor, from reclaiming full ownership of the property after repaying the loan. Such clauses are void because they undermine the fundamental principle of the borrower's right to redeem their property upon repayment. Option B is correct because an option to purchase, if exercised, would extinguish the borrower's equity of redemption, violating this inherent right. Option A is incorrect because collateral advantage clauses are not considered clogs and are enforceable even if their benefits extend beyond the term of the mortgage. Option C is incorrect because indemnity clauses are limited by Section 8 of the Interest Act and do not interfere with the equity of redemption. Option D is incorrect because acceleration clauses allow the lender to demand full repayment upon default, but do not prevent the borrower from redeeming the property if the debt is paid. Question 30. Where a borrower believes that the amount of interest being charged is excessive, under which statute might relief be granted? Correct answer, B. The Business Practices and Consumer Protection Act. Explanation. The Business Practices and Consumer Protection Act allows courts in British Columbia to grant relief if a mortgage transaction is found to be harsh, unconscionable, or where the cost of the loan is deemed excessive. This statute gives the court the power to intervene and potentially modify the terms of the loan. Option B is correct because this act specifically addresses situations where loan terms are oppressive or unfair to the borrower. Option A is incorrect because the Interest Act does not impose a cap on interest rates or provide relief for excessive rates. Option C is incorrect because the Land Titles Act primarily governs land title registrations and does not address issues related to excessive interest rates. Option D is incorrect because options A and C are not applicable in the context of relief for excessive interest rates. Question 31. When an order absolute of foreclosure is obtained by a petitioner who is in the position of second mortgagee, which of the following is false? Correct answer, C. All other charges, liens, encumbrances, and interests registered on the borrower's title are foreclosed or wiped off the title. Explanation. An order absolute of foreclosure in British Columbia does not wipe out all other charges, liens, encumbrances, and interests on the title. It only forecloses the borrower's interest in the property, but it does not affect other registered interests. This is why option 3 is false. Why other options are true. Option 1 is true because after the foreclosure is absolute, the second mortgagee can no longer sue the borrower on the personal covenant to repay the mortgage debt. The foreclosure effectively ends the borrower's right to redeem the property and removes any remaining personal liability under the covenant. Option 2 is true because the order absolute of foreclosure allows the second mortgagee to take title to the property, extinguishing the borrower's interest in the property. Option 4 is true because once the petitioner, second mortgagee, takes title, they are not obligated to account for any surplus or profits from selling the property in excess of the mortgage debt, unless other agreements or laws require such an action. Question 32. Which one of the following is not an implied term of a mortgage? Correct answer, C. The borrower is entitled to assign the mortgage. Explanation. Option C is correct because the borrower is not inherently entitled to assign the mortgage. A mortgage is typically a personal contract between the lender and borrower, and any assignment, transfer of the mortgage would generally require the lender's consent. This is not an implied term in mortgage law. Options A, B, and D are incorrect because they are indeed implied terms of a mortgage. The borrower has the right to redeem the mortgage within a reasonable time, option A. The borrower can redeem the mortgage free from terms that unreasonably hinder redemption, such as a clog on the equity of redemption, option B. The borrower is free from any unreasonable collateral advantages, option D, which would include terms that unfairly benefit the lender beyond the scope of the mortgage agreement. Question 33. After an order nisi of foreclosure is granted to a petitioner and the respondent borrower fails to pay the amount due as required by the order, the petitioner may apply for, correct answer, D, either 1 or 2. Explanation. Option D is correct because after an order nisi of foreclosure is granted and the borrower fails to pay the required amount, the petitioner lender can apply for either. Order absolute of foreclosure, option A, which finalizes the foreclosure and results in the lender taking full title to the property. Judicial sale, option B, which allows the property to be sold, often to recover the debt owed. Option 3 is incorrect because an equitable charging order is not applicable in this context. This order typically relates to securing debts where the court grants an equitable lien on a property, but it is not relevant to the foreclosure process. Question 34. Which one of the following is not a Mortgagor covenant? Correct answer, C. To convey the property to the mortgagee at its option in exchange for an amount equal to current market value. Explanation. Option C is correct because to convey the property to the mortgagee at its option in exchange for an amount equal to current market value would be considered a clog on the equity of redemption. This would prevent the mortgagor from redeeming the property, which is contrary to the principle that the mortgager must have the ability to redeem the property once the debt is repaid. Such a covenant is void because it violates the equity of redemption. Options A, B, and D are common Mortgagor covenants. Option A. Mortgagors often covenant to pay all taxes on the land and improvements, ensuring the lender's security is not diminished by unpaid taxes. Option B. It is common for a mortgagor to covenant to keep the premises in a reasonable state of repair to maintain the value of the property. Option D. The covenant to pay the debt and accrued interest according to the agreed schedule is a standard clause in mortgage contracts. Question 35. Which of the following is not a requirement under the Interest Act in order for a borrower to tender prepayment of their mortgage? Correct answer, D. The lender is a financial institution. Explanation. Option D is correct because the lender does not need to be a financial institution for a borrower to have the right to tender prepayment under the Interest Act. Section 10 of the Interest Act does not specify that the lender must be a financial institution. Options A, B, and C are requirements under Section 10 of the Interest Act for a borrower to tender prepayment. A. The borrower must be an individual. B. The mortgage must not be payable until a time more than 5 years from the date of the mortgage. C. The expiration of the 5 years from the date of the mortgage must have occurred. These conditions are necessary for the borrower to exercise their right to tender prepayment of the mortgage without penalty, as specified in the Interest Act. Question 36. Which of the following contractual clauses in a mortgage could apply where the mortgage is otherwise in good standing, but the borrower has not paid their property taxes? Correct answer, D. An omnibus clause. Explanation. An omnibus clause allows the mortgagee to pay amounts due on behalf of the borrower, such as property taxes or strata charges, if the borrower fails to do so. These unpaid amounts are then added to the mortgage principal, which increases the borrower's debt. Option A, further charges clause, typically relates to adding additional charges or obligations to the mortgage, but it's not specifically for paying unpaid property taxes. Option B, repayment clause, refers to the terms for repaying the loan and does not address the specific situation of unpaid property taxes. Option C, acceleration clause, triggers the immediate repayment of the full loan if the borrower defaults on any terms of the mortgage, but does not directly address unpaid property taxes specifically. Thus, the omnibus clause is the most applicable in this case. Question 37. Which of the following is not an example of an equitable mortgage? Correct answer, D. A mortgage that is unregistrable in the Land Title Office as it is prohibited by statute. Explanation. Option D is correct because an equitable mortgage cannot be prohibited by statute. If a mortgage is unregistrable because of statutory restrictions, e.g., the mortgage is not allowed under the law, it is not considered an equitable mortgage, as it cannot even exist legally. Option A. A mortgage disguised as a transfer of land, where the sale price is below market value, is an example of an equitable mortgage because the transaction is not actually a sale, but a disguised loan. Option B. An agreement to execute a mortgage in the future, under which the borrower has already received the principal amount, is an example of an equitable mortgage because the loan is advanced before the formal execution of the mortgage agreement. Option C. A mortgage created by providing a lender with a duplicate certificate of title as security for the loan is a common form of equitable mortgage, as it involves providing a certificate of title as security, but not the formal registration of the mortgage. Therefore, option D is the correct answer, because a statute preventing registration of the mortgage makes it invalid, not merely an equitable mortgage. Question 38. An option to purchase the mortgaged property given by the borrower to the lender at the time the mortgage is negotiated is. Correct answer, B, void. Explanation. Option B is correct because an option to purchase the mortgaged property given by the borrower to the lender at the time of the mortgage is considered a clog on the equity of redemption. The borrower's right to redeem the property upon repayment of the loan should not be restricted or prevented by giving the lender an option to purchase the property. Therefore, this clause is void. Option A is incorrect because independent legal advice does not make an option to purchase enforceable. Even if the borrower receives legal advice, the option still constitutes a clog on the equity of redemption and remains void. Option C is incorrect because such an option is not enforceable in all cases. It is void due to being a clog on the equity of redemption. Option D is incorrect because an option to purchase is not considered a collateral advantage in the modern sense. It is considered a clog on the equity of redemption rather than an advantage related to the mortgage itself. Thus, the correct answer is option B, because the option is void as it is deemed a clog on the equity of redemption. Question 39. A mortgage that is granted, but for procedural reasons is not registrable is. Correct answer B, recognized as a present equitable mortgage. Explanation. Option B is correct because a mortgage that cannot be registered due to procedural reasons is still considered an equitable mortgage. Even though it may not be in the correct form to be registered as a legal mortgage, it still creates an enforceable interest in the property, just in equity. Option A is incorrect because an equitable mortgage is enforceable even if it is not registered. It is not required to be registered to be effective, though registering it can give it additional protection. Option C is incorrect because while filing a caveat can protect the lender's interest in some cases, it is not the only protection available. An equitable mortgage can also be protected through other means, such as by handing over the duplicate certificate of title to the lender. Option D is incorrect because a legal mortgage requires proper registration, and if the mortgage is not registrable for procedural reasons, it is still treated as an equitable mortgage, not a legal one. Therefore, the correct answer is option B, as the mortgage is recognized as an enforceable equitable mortgage despite its procedural issues preventing registration. Question 40. Which of the following most correctly completes the phrase, "a mortgage is"? Correct answer, B, a contract, evidence of a loan, and security for a loan. Explanation. Option B is correct because a mortgage is a contract between the borrower, mortgagor, and the lender, mortgagee. It is evidence of a loan, the debt, and it serves as security for that loan by granting the lender an interest in the borrower's property as collateral. Option A is incorrect because while a mortgage is a contract and evidence of a loan, it is not required to be registered to be effective between the parties. The registration of a mortgage is necessary to protect the mortgagee's interest from third parties, but the mortgage is still valid between the lender and borrower without registration, as per Section 21 of the Land Title Act. Option C is incorrect because a mortgage is not a loan itself, but rather a contract that provides security for the loan. Option D is incorrect because while it is true that a mortgage serves as security for a loan and is a contract, it is not required to be registered to be effective between the parties, as registration only affects its priority relative to third parties. Therefore, option B is the most accurate description of a mortgage. Question 41. Which of the following is an example of an equitable mortgage? Correct answer D, all of the above. Explanation. Option D is correct because all the listed scenarios are examples of ways to create an equitable mortgage. Explanation. Mortgage of the equity of redemption. This refers to mortgaging the borrower's equitable interest in the property, which remains after the legal mortgage is granted. The borrower retains the right to redeem the property upon repaying the loan, but the lender holds an interest in the equity of redemption. Agreement to execute a legal mortgage. An agreement to execute a legal mortgage in the future is recognized as a present equitable mortgage. Even if the formalities of executing a legal mortgage have not yet been completed, the courts may enforce an equitable mortgage if the borrower has agreed to grant a mortgage. Mortgage by way of deposit of the duplicate certificate of title. This occurs when the duplicate certificate of title is deposited with a lender as security for a loan. This is a common form of equitable mortgage, as the lender is holding the certificate as collateral for the loan, even though the mortgage itself is not yet legally registered. Each of these examples reflects situations where an equitable mortgage is created, either by informal agreements or by holding collateral like the certificate of title, which are recognized by courts even if they don't meet all the requirements of a legal mortgage.